Welcome to another episode of the Healthcare Legal Digest. Today we are going to be talking about the DIY will, that is the do-it-yourself will. And we're going to be looking specifically at some of the pitfalls that you may not be aware of, and we want to bring some of those things to your attention so that before you go ahead with your DIY wills, you will have all the necessary information. So creating a will is one of the most important steps that you can take to ensure that your assets are distributed according to your wishes after you are gone. And with the rise of online templates and DIY will making kits, it is now very easy to draft a will without professional help. At first glance, this seems like a convenient and cost-effective and straightforward way, but convenience can come at a price. The DIY will may save you a trip to an attorney, but often it comes with the pitfalls that can create more problems than they actually solve. So a poorly drafted or a legally invalid will can lead to disputes and delays and unnecessary expenses, and really puts you in the position that you might be if you had no will at all. Now, if you're considering creating a will on your own, it is important to understand all of those risks and then be able to determine whether or not it is worth investing in professional guidance. So here are some of the pitfalls that we're going to be looking at today. One is the legal language. Legal language matters. One of the most significant issues that we come across with DIY wills is the use of improper or vague language. Legal documents need to be precise and unambiguous. Without the right terminology, your instructions could be misinterpreted, and of course that would lead to unintended consequences. Here is an example. In your DIY will, you may say, "I leave my estate to my children," without specifying how the assets should be divided. Does it mean equally? Does it include stepchildren or only your biological children? Ambiguities like this can lead to disputes that then end up in court. Attorneys are trained to use clear, legally binding language, and that would avoid many of the misinterpretations that can come without the benefit of that very specific language. So while it might seem like a small detail, the precise wording of your will can make a big difference between a smooth estate distribution and a long, drawn-out legal battle. So that is the first thing to bear in mind, as, like I said, the pitfalls that you may come across when you attempt to do your will on your own. The second thing is that laws vary. Estate laws differ from country to country and from state to state. And what is valid in one place might not be valid in another. So DIY templates often fail to account for these variations, and this can result in your will being partially or entirely invalid. An attorney can ensure that your will complies with the laws in your specific jurisdiction, giving you that peace of mind that your wishes are going to be honored and in the way that you intended. Now, the third pitfall is that complex estates require expertise. Complex estates require expertise. DIY wills might suffice for very simple estates. But if you have significant assets, you have multiple beneficiaries, you have blended families, or specific conditions that you want to impose, such as age restrictions for inheritance, a DIY will may not provide the flexibility that you would need in those circumstances. An attorney can help you to navigate those complexities and create a will that is tailored to your unique situation. Now, the fourth thing is that DIY wills can be disputed more easily. So they are more vulnerable to challenges in cases where a will is being contested. Family members or other parties may argue that the will isn't created properly, or that you lack the mental capacity to draft it at the time when you were creating the will, or that it doesn't reflect your true intentions. And without the guidance of an attorney, there is no one to verify that you understood the document and signed it willingly at the time when it was being created. This can lead to costly and time-consuming disputes that undermine the very purpose of having the will in the first place. The last tip that we want to share with you today is that the cost of the mistakes can be very high. So while your DIY will might save money upfront, the cost of fixing these mistakes at a later stage can far outweigh the initial savings. If your will is unclear, incomplete, invalid, your loved ones may need to hire an attorney at that point to go through probate court or even deal with other lawsuits that they may come across if the will is being challenged. So there are cases in which the entire estate could be distributed according to intestacy laws, essentially as if there was no will at all. And this can result in assets going to unintended beneficiaries or being divided in ways that do not align with your wishes. So, are there any circumstances in which you can use a DIY will? Well, certainly. There are situations where doing your own will might be sufficient. If your estate is small, straightforward, and free of any complexities, then a DIY template could serve as a basic plan. However, even in those cases, it is still worth consulting an attorney to ensure that your will is legally sound. Many attorneys offer affordable estate planning services that provide a far greater assurance than a DIY approach. Creating a will isn't just about filling in blanks on a template. It's about crafting a document that reflects your unique life, your relationships, and your priorities. An attorney can help you think through scenarios that you might not even have considered. Things such as who will manage your estate if your primary executor cannot serve? How will your assets be handled if a beneficiary passes before you? Are there any tax implications for your beneficiaries that you should plan for? By investing in professional guidance, you're not just paying for a document, you're paying for peace of mind, and your loved ones will be and the assurance that your loved ones will be cared for and that your wishes will be respected. Estate planning is far too important to leave to chance. If your situation is simple and you decide to go the DIY route, then proceed with caution and make sure you understand the legal requirements in your particular state, country, or area. For everyone else, working with an experienced attorney is the best way to ensure that your will is clear, valid, and tailored to your needs. That's all for today's episode. Remember, if you have any questions or topics that you would like us to cover in our future videos, please drop them in the comments below. We also invite you to like, share, and subscribe to our channel and help keep this information accessible to all our seniors. Thank you again for watching, and see you again in our next video.